Okay. All right. Thanks. So, good afternoon. It's nice to be back. The first thing I'm going to let you know is I've got really good news in that I am not going to speak for 40 minutes. So I think your break is actually going to be a little earlier than you thought it was. So I just want to let you know that. I'm actually going to chat with you for maybe 15 or 20 minutes and then take any questions that you may have, and then we'll call it because I know it's a long day and I know you've got other things that you'd like to do as well. And you all know where I am because I come here twice a year and I give you updates all the time. So thanks so much for having me once again. I really, truly do enjoy coming to chat with all of you and give you some updates on what's happening at the Law Society these days. I guess I can, not to put too fine a point on it, but we've had a bit of a sea change in the room at the Law Society. Our first quarter of the year was, as you can imagine, extremely busy, coming to a conclusion with our prior bencher group and term and moving to and preparing for the bencher election, which was a lengthy activity, and there was a lot of busy communications and social media activity around all of that. Our first month of Q2, of course, saw a successful voting period come to closure and announcements of the election results, and I'll talk about that a little bit more in a moment. But it's been quite a busy time of year for us. Today I'm only going to touch on a few highlights for you, and I've outlined them here. I, as I said, do appreciate getting to speak to you twice a year because it allows me to keep these brief and just focus in on things that I think are most important for you and for all of your members in your various associations and locations. It's nice to split time too in the Law Society. For those of you who weren't aware of it, I know there's some breakout rooms later after this session or after the break, which I'm going to get you to earlier. And my colleagues Priya Bhatia and Jennifer Neese are here talking about CAN, so if you have the time to go to that breakout session, I'd certainly encourage it because it is an incredibly important and supportive program. And just to the panel that was here before me, a program that connects lawyers with other lawyers and paralegals with other paralegals to help them with any practice issues, immediate crisis matters in their practices. And that can always be very helpful and also stave off issues related to angst and stress and other matters. So if you can take the time to go to those sessions this afternoon, I'm sure Priya and Jennifer will be happy to see you there. So as you know, our bencher election just concluded on April 28th at 5 p.m. and the results were announced on May 1st. We have a majority of newly elected benchers in the room. 63% of the room now are fresh eyes, which is a very interesting situation for the Law Society to be in. It's the first time since I've been at the Law Society where such a significant majority of our new board members are coming to us with new perspectives. And I've been at the Law Society for over 21 years now. So this is a lovely change to see. It's always good to get new perspectives from the professions because it's what informs us as a regulator with respect to what we can do and the practical implications of what we're doing as a regulator. 63% as well of the group are women, an amazing milestone for the Law Society. So shout out to all the women because that's great to see as well. First time in our history. It's going to be wonderful to have parity in the room and to progress on issues that I know are important to all of us as men, women, others, and parents and individuals dealing with elder care and other issues. It's a busy time out there, and the more variety and diversity we can have of perspectives in the room, the better it makes all of us. The election did see a lot of our members of the Good Governance Coalition, the group that referred to themselves by that name, elected into the room, as you know. And I'm certainly looking forward to seeing how we will actually move ahead with implementing new good governance procedures at the Law Society. It's my job, of course, to help support the board to achieve the goals that they are going to prioritize, and we'll see how they would like to take that forward as they move ahead. Our main function, of course, as the Law Society is to protect the public from harm, but the better our governance protocols and policies are and the better informed we are as a regulator, the easier it is for us to actually be able to ensure that that public is protected. The new term for our benchers actually starts on May 25th at our convocation, so that's officially their first day. as elected representatives who are going to be voting on various activities as we move forward. These benchers will serve until May of 2027, so they have a 4-year term. They've got quite a bit of time to get their policy agendas and priorities set and to actually work them forward and achieve their outcomes. The Law Society, my team and I have already commenced the onboarding with all of the board members, so we had, no, go ahead. Yeah, no problem. We had a full day actually of orientation yesterday at the Law Society for all of our new board members, and it was nice to see almost every single one of them in attendance. A few had some hearings and litigation matters and other matters that couldn't bring them in, but everyone's very engaged and very keen, and they're learning a lot because at the Law Society, with over 70 different types of programs, processes, and activities that we have to support based on approvals and other activities that have been set in the past and that we now have to tend to, it is a very complex and complicated place, and it does take our board members quite a bit of time to come up to speed and to really understand the implications of all of the work that has to be done for our over 70,000 licensees in the province. So we'll head into strategic planning as well with this group, and that'll commence in the next couple of months. And then we'll go to a strategic planning session in September where the new venture team will set their priorities for the next 4 years. They'll set the bigger picture priorities at a very mission vision level of acuity, and then it is up to my senior executive team and I to determine what the tactics will be underneath each of those priorities to ensure that we're moving forward with the plans and bringing forward an evolution and modernizing as a regulator. So it should be very exciting. I know I'm very excited about it. Let me just chat a little bit about annual reports and the annual general meeting. So our 2022 annual report is now available online at the Law Society's website, lso.ca/annual report. It's chock full of great information and data and details about the professions and what's going on. I always encourage members to take a look at the annual report. I know it's not something we all do is trudge to a website and look at these things, but for you as leaders in your local associations, the numbers that are in that report are really important. They give you a really good understanding of what's going on across the province and the types of activities that we're undertaking, the demographics of the profession, where things are going. It's very important data, and as always, I'm always available to address questions or answer any questions that you may have. Always happy to receive a direct outreach from anyone in any of the regions to find out what you're thinking and if I can help you in any way. I know often you may have meetings with your local associations where they may also have an interest in some of this data, so if that's a request, you can simply ask, and if it's not my office, certainly Sheena Weir's office will be able to help you to provide you with the information that you might need to make a great presentation so that your colleagues understand what's going on in the profession these days. It's always very helpful information. We decided this year to use the annual reporting as another opportunity to just finally cap off and celebrate our 225 years as a regulator, as the Law Society. So there's a very interesting timeline as well as part of that annual reporting. It'll visually take you through a number of the milestones, both for the Law Society as an organization, but also for the profession. So it's an interesting graphic for you. You will probably already know that we had our annual general meeting yesterday evening, and some of you may have even participated virtually in that. Certainly Doug participated virtually. You'll know that there was a motion at the AGM that was put forward by Doug seeking to have the Law Society consider how to bring lawyers to underserved communities in Ontario, and that motion did receive the necessary support to move it forward in and through the Law Society. So under our bylaws, that'll now be considered. By convocation, they'll be informed that that's happened, and then they'll have 6 months to actually put their mind to what that means and what we will do about it going forward, and then you'll be hearing more about that. So obviously an important issue, the aging of the bar and succession planning, and I know I've reported previously to you on the Law Society's efforts to help the profession to engage generally in succession planning. So I'm going to make one more plug because I've got an opening here, and I'm not going to fill all my minutes. Succession planning, especially in the regions and the locals, is so important. We do have services and supports that can help, but if you and your members can cast your mind to those issues at least once a year to remind yourselves that if you do not have someone under a power of attorney who has been designated to help in case something goes wrong with you or your practice, it is critically important that you think about that, if not for yourselves, for your families who are going to be left behind and stuck with your practice. So getting that message out to all of your members is really important, and I like to reinforce that every year. With an aging bar, this is becoming a huge issue for us. Trustee services at the Law Society is incredibly busy, and usually it's because they have to parachute into a practice because someone is in the hospital or has passed and has left a practice without any supports. So I know it's a depressing topic, but it's an important one. So if you could relay that to all of your members, we, again, really appreciate that. Moving on to a snapshot of the professions, I always like to give you a little bit of data as I sit here with you, and I want to share some statistics for you just so that you continue to have an idea of where we're going as professions in Ontario. The number of lawyers licensed and practicing continues to be on the rise. We had 43 more lawyers licensed in 2022 as compared to 2021. That doesn't seem like a lot, except when you consider that we didn't have as many retirements or as many removals from the practice. So in actual fact, in 2022, we had 1,257 more practicing lawyers overall than we did the year before. That's including all the entrants and all the exits. So we're going up on a fairly decent percentage ramp, and that's been the case for about a decade now. It's not slowing down. The number of paralegals is licensed in 2022 is actually only half the number in 2021, but at the end of the day, because of the way the numbers work out, they're just staying stable. So it's a bit of flatline growth there for paralegals. No real difference in the numbers overall. We have 57,577 lawyer licensees and 10,633 paralegal licensees as at December 31st of 2022. That's the group that we're looking at now. And this is across all categories of licenses. So that's private practice, that's also practicing in-house or in government or in another environment. It's also those who are not practicing but are maintaining their licenses. They may be practicing in they may be working in other areas that actually don't require them to provide legal services. It also includes those who are retired or may have been on leaves of absence but are maintaining their status as a licensee. So of the 57,577 lawyers that we had at the end of 2022, about 42,500 of those were actively practicing in a legal environment in Ontario. So that's still quite a number of lawyers. It's getting right up there. I think the last time I was here, I reported to you that we had one practicing lawyer for about every 450 people in the province. So those are our numbers in round figures. From the perspective of law firms, we're staying pretty stable. We've got about 11,500 law firms in the province, but interestingly, as it always is, 8,800 of those are solos of the 11,500. Big amount. Yeah, there they are. Yes, shout out to the solos. Well done. So there is that's a large number, and one of the reasons why the Law Society keeps very busy, because between our resources and our activities, the solos are the folks that we want to be able to support and assist, and there are a lot of you. Finally, I just wanted to mention that our complaints that are referred to the Professional Regulation Division and the number of discipline notices that were filed in 2022, those are both down, slightly down, but I'll take everything I can get. So slightly down. And now this could potentially still be a bit of a result from a lingering pandemic effect. It took us almost 3 years to get into that COVID situation and pandemic, and now it's going to take us quite a few years, I think, to roll out of it effectively. So we'll watch this trend carefully. It'd be nice if the numbers of complaints and discipline notices kept going down. I'm not quite confident about that because we also have a lot of other issues coming from other areas. So aging of the bar is one that I've mentioned. The number of discipline notices for more mature members of our profession is much higher than their population. We see that a lot. Those who are practicing more than 30 or 35 years have a significantly increased percentage of discipline notices being filed for misconduct. And we're also seeing, of course, the issues of capacity and mental health really having a significant impact on practices, and at times those issues end up in complaints and investigations as well. So we're spending quite a bit of time at the Law Society in our professional regulation division doing substantial work on mitigating capacity issues, trying to redirect those matters to remedial situations where we can help and protect not only the individual and their mental health, but also protect the practice and the clients of that practice, so that everyone has an effective result at the end of the day, regardless of the health situation. So a lot of work is going into that in the regulatory area. It is certainly one of the, if not one of the most emerging areas of every professional practice, whether it's law or whether it's medicine or dentistry or any of the professional practices. Something to keep an eye on as well in your regions. To the point I made earlier about reminding your members that we are available to help if you see a colleague or anyone with issues. Trustee Services is confidential, and they have lots of supports and lots of places that they can connect you and your colleagues with others to get help. Moving on to some policy initiatives, mandatory minimum compensation. The requirement now is to pay $620 per week gross pay to all experiential training candidates, so articling candidates and candidates in the law practice programs. This is in force now, and it started on May 1st. Principals or work placement supervisors can apply for an exemption, but there are 3 qualifiers that they'd have to meet to get that exemption. One is that, of course, they're providing a high-quality training experience. They have to have an inability to pay, and they have to be able to show us that inability, and they have to have a clean discipline history. So our team at the Law Society is proactively communicating with all the people that this new policy affects, and we are making sure that this will be adhered to. The Law Society is going to be contacting any principals who are not paying candidates accordingly and have not been granted an exemption to assist them to bring themselves into compliance, either through paying the minimum compensation or by obtaining that exemption. If the principal fails to bring themselves into compliance, the consequences could include ending that principal's eligibility to act as a principal going forward. If non-compliance continues to occur in subsequent years with subsequent candidates, there's also a chance that we would end the placement with that supervisor entirely. So it's something to be mindful of. The Law Society is going to be working in partnership with the law practice programs to determine how compliance with minimum compensation is going to work there during the work placements. And we'll be reporting back periodically to the relevant committee at the Law Society with the outcomes and any difficulties and issues that we're facing as we move forward. But you will likely all recall that this came forward through a rather circuitous route through convocation with many hurdles and many steps to be taken. And the effort here is to ensure, much to the questions that were asked earlier, that articling candidates and experiential students in the law practice program are supported, are being paid for their good work, are able to make a living, because it is a stressful time in your life, and you should be paid for doing this work if you're doing it, unless there's an exemption and there's other good work that you're able to support and do with your employer. So this is something to keep an eye on in your areas. Another policy initiative, a consultation on the Certified Specialist Program. This consultation is going to be launched in the coming weeks, and it's going to continue through into October. The consultation is going to determine the future of the Certified Specialist Program that the Law Society provides, and also includes a consideration of the use of the CS designation for those lawyers who already have that designation, have completed the program. There is a report that you can review. It's not actually a terribly long report. as well as a questionnaire that comes along with that report that you and your colleagues can fill out. And they're all found at the Law Society's website at cs-consultation@lso.ca. Or you could simply email your feedback to policyconsultation@lawsociety.ca to give us your thoughts on the Certified Specialist Program and its future. We also have now a guide to experiential training, and now this is a new resource that was launched on May 17th. It's been a long time coming. We've had a lot of inquiries from both supervisors and also articling students and experiential candidates in the law practice programs for supports and resources to help them manage through the process of performance during placement. It's a new series of online learning modules and videos and resources that will help experiential training candidates acclimate to legal practice and also prepare supervisors and principals to orient their new candidates using effective practice management techniques as well as effective performance management techniques. The guide has two different streams, so there's one for the candidates and one for the supervisors. The candidate stream does cover a variety of subjects and topics to address the challenges that are most frequently reported by candidates during training, such as what to expect during that training, how to receive regular feedback in the workplace, how to ask for that feedback, how to integrate that feedback into your activities, how to maintain work-life balance, and manage all the other important activities that you should be focused on as well in your day-to-day life. The supervisor stream will help supervisors and principals to understand their overarching obligations. It'll incorporate best practices for managing and coaching, and it will provide tools to assist with challenging conversations, how to give performance feedback, how to receive feedback from your articling candidates themselves directly and receive that positively and do something positive with that feedback. So there's information there as well. So we certainly hope that this new resource is going to help both the candidates and the supervisors as they move forward, and will ideally provide them with an easier path to actually managing conversations that can be quite difficult, as we all know. The last policy initiative I want to talk about today is the Practice Essentials course. So in May, Convocation approved a new competency framework, and that included as well the creation of a new Practice Essentials course, which is going to be mandatory for all lawyers or paralegals within 1 year of setting up as a sole practitioner for the first time. It's going to be an online, self-paced course with modules that is going to provide licensees with flexibility to learn while attending to their professional and personal obligations as well. The course is intended to set new sole practitioners up for commercial and professional success. And it's going to do that by ensuring that all licensees who are starting out in new firms as a solo are equipped with the requisite knowledge and resources to operate as solo practitioners. As you know, the reality is that the majority of notices of application for discipline matters are issued against licensees who are sole practitioners. I just mentioned that we have 8,800 of them. That's a large number. It stands to reason that a lot of these notices are likely to be in this category. Sole practitioners represent 32% of the profession, but they're over 70% of the discipline notices. This course and this approach is meant as a proactive means of assuring competency in the immediate post-licensing period for a sole practitioner. It's meant to apply risk mitigation strategies, both for the sole practitioner as well as for the Law Society. As a regulator, we don't want to be issuing notices of discipline to sole practitioners, but we do need to help those sole practitioners to avoid that. It's an opportunity here for us to help soles to be more viable and to actually support the needs of the public who are looking to those sole practitioners for assistance. Ideally, this will set them up and make their practices more viable. And the course is currently under development. It's going to take us some time to get there, and we're going to take our time. We're going to perfect it and make sure it's very supportive. It's also practical on the ground in its implementation. It's also going to require us to operationalize a few other policy decisions, so it'll take us a bit of time to get to the completion of this particular course, but then we'll be communicating with everyone as we get closer to moving this forward and implementing this as a required mandatory component of becoming a solo practitioner. Final comments from me, just a few highlights and reminders for everyone. Law Society Awards on May 24th. You can join us virtually for those. It's always a really great event, and it's an opportunity to hear from and recognize our colleagues who've made tremendous contributions to the profession and to the public interest. Our equity events are always featuring very interesting speakers and topics, and there's a few that are coming up soon, and just want to encourage you to make sure that everyone knows that they're available, because they also do count to your towards your EDI professionalism hours for your CPD credits. National Accessibility Week, the National Indigenous History Month, and also Pride Month programs are coming up, so keep an eye out for those as well. And always like to end by reminding you that we have tons of resources at the Law Society to assist individuals who are looking for help, from everything from getting advice on a legal a practice matter through to continuing professional development, resources and supports, a lot of assistance with regard to mental health, to the session before me, the member assistance program. Never forget that that's available, very important program that's completely confidential, and other supports. And we do have a handy sheet on our website that sets that all out for you. So please make sure that you're turning your members towards those resources and letting us know if there's anything there that you could use that's not there, because we're always happy to hear from you with regard to proactive, supportive events and activities. So really that's it for me today. I wanted to keep it pretty brief and also allow you the time to ask me any questions you may have. So I will open it up to anyone who has a question for me. I usually get a few.
Hello, Corey Wall, Central East representative for FOLA and the treasurer now. This is more of a comment, and I just wanted to encourage the Law Society, when you're looking at the succession planning for lawyers.
Sure.
My practice is restricted to estate litigation, so I'm a big fan of good succession planning.
It's a pitch there.
But the other thing that I would encourage the Law Society to look at from the point of the public interest, and also trustee services budget and things like that, is I wonder if looking at things like some amendments to the Solicitors Act that might mirror some of the substitute decision making and some of the other legislation that we see in place for the public that deals with people more generally, but could be specified for licensees, that would allow trustee services to save in some of the resources and time that's used in them getting appointed to handle licensees' practices that haven't perhaps met the standard for succession planning. Because I think that's something that's in place for the public as far as substitute decision makers, and if we were to put something like that in place, it's something that I think might actually help and assist. I agree with you that we all have a duty to do proper succession planning, so that's the first step, all right? I encourage everybody in this room, please do that. But for those that don't meet that standard, you know, the Law Society is the one that's going to have to step in and deal with that as far as dealing with the public. And that's an avenue and an approach that I think might assist in addressing some of the, because I know that there's a much bigger strain on trustee services than there has been in the past, and as the bar grays, these issues are only going to become more and more important and more of a drain on the budget and resources. So I just think that that's something that should be considered in addition to licensee succession planning.
So I appreciate that. I guess the only comment I'd make is that finding those substitute decision makers or putting a protocol in place where that's actually going to be supported should there be an unfortunate incident is still a process and a protocol that needs to be supported and paid for. One of the beauties, and you're right, the trustee services has had a lot of activity lately, but I guess one of the beauties of having trustee services at the Law Society, which is a supportive opportunity, is that one way or the other, we're going to all, as licensees, pay for these activities. And doing it at the Law Society in that contained environment where we have, and I don't know if you're all aware of this, but our trustee services unit has a huge list of different individuals in different practice areas across the province who we rely on. So we don't take a practice and then do anything with it ourselves. We take a practice and we give these files to other lawyers. So they are, let's say, because of an unfortunate incident, they are gaining files of clients. If they're prepared and willing to help us to take those files on, and many, many of your colleagues, thankfully, are very, very willing to help us out. So we are always reaching out to members of the profession in various practice areas to ask them if they'd be willing to help us to take clients on because something's gone very wrong and the clients have, the files are just there, they've been left. So I appreciate the comment, and I will take that back and take a look at it, but if you have any other information on that, if you could shoot it to me, that'd be great. Thank you. Thanks. Any other questions? Hi.
Hi, my name's Jessica. I'm from Sudbury. Just quickly, I wanted to just bring to your attention, while the mandatory minimum compensation requirements are a huge move forward with respect to the treatments of experiential training in our area, and I'm sure you're not going to be surprised to hear the next bit that I want to say, but it's not enough, and I know there's a division in the bar about this. But just to bring to your particular attention, I just quickly added up the cost for a recent articling student who is paying for their articling program, their bar materials, the call to the bar fee, and the writing, sitting fees, and that totals just over $5,000. Mm-hmm. If you look at $620 a week over the period of the 10 months, almost, the first quarter of those fees that may be paid as wages, that student is paying directly back to the Law Society. So I just might put to you that both the considerations of the obligations of employers to pay their employees should be considered on top of the idea that these are young or new professionals who not only are they now graduating tens of thousands of dollars in debt, it's not the good old days where it's $2,800 for a semester of law school, it's now almost $30,000 a year at most Canadian institutions. If we're going to tell employers you need to pay them at least $620 a week, it's a tough pill to swallow for the recipients of those funds to say, but give the first quarter back to us. So it's just something to think about, and I'm sure you've heard that before. But yeah, so while I'm grateful that we have a mandatory minimum, if you add it all up, and the hours that these articling students are doing is not even minimum wage, and respectfully, they're being gouged with respect to the costs that they're inheriting just after graduating from a very, very expensive and prestigious program. So yeah, I think there's obligations on both sides.
No, okay, thank you very much for your comments. I mean, I don't disagree with anything you said, but I guess the good news is we're here finally. Yes. It only took us 225 years to make sure, to make sure that actually articling students were paid. Yeah.
So and it's going to be out of date.
So I'm delighted that we at least got this far, and I assure you that we will continue to try to push this forward.
And just to bookend that, with the planned increase in minimum wage show the province, we're not even hitting minimum wage for a 40-hour work week with this compensation. But at the same time, we're told as employers we have to follow the Employment Standards Act in almost every other circumstance. So is there a plan from the LSO to include some type of indexing or consideration for raising that as our province acknowledges the right for workers to fair pay as well?
Sure. Well, as I said, this matter is going to be coming back to the various committees to look at how it's proceeding and how it's progressing. And one of the most important things we're going to see now is how many employers are perhaps going to back out of actually providing articling jobs, or how many employers are going to ask for exemptions. We're prepared for all of that, but we need to see. It's a commitment. It's like the motion that was passed last night. It's one thing to say we're going to do something. It's another thing for everyone to commit that we're going to have lawyers in the outlying provinces because we're losing our practitioners because of the aging of the bar. Everyone has to step up, support, make sure they're welcoming them into the community. It's the same with the articling candidates. If you're not welcoming them in and paying them a proper wage and actually supporting them and giving them the 10 days off, which, by the way, isn't just vacation. It's 10 days however you'd like to apply it, and then you can adjust with your employer as you see fit. But one of the other issues is making sure employers recognize the need to be open about those requests, all of that needs to be taken into account.
Right, and on that point, I think my friend's comment there too was the Law Society doesn't tell the employers
That's
they have an
right.
obligation to be letting people be ill or sick and out of the office when they have that time, and that's kind of compounded on the power imbalance between
The Law
articling
Society,
students and
remember, the
principals.
Law Society's obligation in this is to say, the minimum you must do,
Right.
and we're telling, or we're coming after you.
Yeah,
The
fair
Law
enough.
Society's taking that away from you, that ability to have an article, so you better give them that 10 days. You should be doing more than that, but there can be no minimum than that. So that's the nuance there.
Fair
But
enough.
you're right, we cannot always enforce that. The contract is between the employer and the article.
Yeah, thank you for your time.
But very good point.
Thank you.
Thank you very much.
On the Practice Essentials course that you're developing for sole practitioners.
Sure.
I sort of want to just bookmark the fact that a lot of those sole practitioners who are just starting out are also young folks. And I think you have to stay very cognizant that even though we say courses are online and they're easy to access, you know, as a young practitioner, there's only so much time in the day. And a lot of them are already having issues with practice-life balance. And we're now throwing one more requirement. And then we also, I think, have to stay very cognizant of how that balances with the regular continuing ed credits, because we keep adding things in. And there's, again, only so many hours in a day. If you've got young practitioners and you're telling them they have to do this course and they have to do that, and they, at some point, the burden to do all the continuing ed is just unreasonable.
So, points taken, and as I said, there are a number of policy issues that still have to be determined as this course comes through. That's going to be one of them, the application of credits. But you're right about the sole, you know, it's a balancing act. As a regulator, we're here to protect the public from harms. But, you know, we're also here to promote goods. So what we want to do is make sure that sole practitioners, because we need sole practitioners. The regular everyday consumer needs sole practitioners in the regions and the locals. We want them to be able to be viable. One of the things we find, and I don't know, I think I've said this to groups previously, when the Law Society is able to come out and assist the sole practitioner, maybe it's not this course, but we come out and we spot audit everyone in the first year or so. When we do that, their viability increases by greater than 25%. They're still practicing and ready to go, more so than a colleague who did not have that assistance, because for as many great sole practitioners who are really on the ball and can get going in their practice, there are a number of them who need a lot of support because they're isolated.
Absolutely, and we have to stay aware that there's many sole practitioners whose original concept is not to be sole practitioners.
Absolutely.
And they end up there because that's the option that's available to them.
It's circumstantial, that's right. Yeah.
And that there's very specific areas of practice where you're going to see more sole practitioners, and then that plays into the whole thing.
And again, this will be an area where we will monitor, but our first priority here is to be helpful and supportive. It's not to layer on more burden.
Right. And
So we'll keep that in mind.
just
Yeah,
things that we have to stay conscious of.
for sure.
Thank you.
Okay. Okay.
Happy to take you to Halton County Law Association. When you're developing this core Practice Essentials course, will you be considering teaching people about legal aid, or how to bill legal aid, about the dilemmas of the cost of legal aid? And I only ask this because I'm a mentor at the LPP program. I have been for years. And several years ago, there was a woman who had been a judge in another country and went through the LPP program, set up her own practice, and after about a year, indicated that she had to leave legal aid completely because she was so stressed out about not knowing how to bill. She was so stressed out about not getting paid.
Sure.
And she was a sole practitioner. And I think, just thinking about her sad experience, you need to teach people about that. If you're going to do it anyway.
Sure, thank you.
And sole practitioners, a lot of them are going to do either criminal or family, which is going to be maybe largely legal aid.
It's a big component. Yeah, thank you for that comment. Yeah, that's great. And after saying I was going to do this really quickly and give you extra time, look what happened, right? Sorry about that. Thank you, Doug.